On 16 December 2012, a 23-year-old woman was brutally gang raped in Delhi. That same month, 5 adults and 1 minor were arrested in connection with the case. After one adult convict was found dead in jail in March 2013, a fast-track court sentenced the remaining 4 adult convicts to death in September 2013. It was only on 20th March 2020, over 6 years after the sentence was awarded, that these 4 convicts were hanged. Before we get into why there was such a delay in hanging the convicts, let us understand the position of the capital punishment in India. The capital punishment is a controversial issue in India and abroad. It is awarded in the rarest of rare cases, usually for the offences of rape, murder, terrorism, and atrocities towards scheduled castes and scheduled tribes. In India, convicts sentenced to the gallows can file up to 4 petitions. Here are some of the steps followed in awarding a death sentence and petitions that may follow. Trials of such cases may take place in a sessions court, trial court, fast-track court, or special court. Following this, the concerned High Court should confirm the sentence before issuing a death warrant. The convict may approach the Supreme Court challenging the High Court's decision. After the Supreme Court's decision is out, the convict can file a review petition. If this review petition is dismissed by the court, the convict may file a curative petition. We know that these terms can get a little confusing. So let's simply say that a convict who has been sentenced to death may file up to 4 petitions against the punishment. The fourth of these is a name we have heard quite often, the mercy petition. So what exactly does that mean? After the capital punishment is finalized by a High Court or the Supreme Court, the convict can file a mercy petition with the President of India or the Governor of the concerned state, depending on the offence for which capital punishment was awarded. The President or Governor can grant pardon to the convict, or delay the execution, or reduce the punishment, or uphold the original sentence. The execution can only be carried out if the President or the Governor rejects the mercy petition filed with either of them. The convict can file a petition with the Supreme Court questioning the President's decision. The death sentence may only be executed after this petition is disposed. Going back to the Nirbhaya incident of 2012, 6 men were accused, of which 1 underage convict was sent to a juvenile correction home for 3 years. One accused, Ram Singh, allegedly committed suicide in Tihar jail in 2013. On 13 September 2013, a fast-track court awarded the death penalty to the remaining 4 convicts. On 13 March 2014, the Delhi High Court upheld the death penalty. On 5th May 2017, the Supreme Court also upheld the death penalty. The sentence said that all 4 convicts had to be executed together. This condition delayed the process for years, as each time one convict filed a petition, the executions of the others were put on hold too. Making use of the fact that convicts can file up to 4 petitions each, the 4 convicts in this case filed petitions one by one for almost 3 years. But finally, all 4 were hanged on 20th March 2020. All this may make you wonder if this is the trend in all cases where the death penalty is awarded in India. As it turns out, 2,493 people were awarded the capital punishment between 2000 and 2018, according to data from the National Crime Records Bureau. Only 4 of these 2,493 were executed as on 31st December 2018. Including the 4 executions from March 2020, a total of 8 convicts have been executed since 2000. The Law Commission of India recommends the abolition of the death penalty in all cases except terrorism and waging war. Meanwhile, the debate on whether the capital punishment should exist or not continues at the national and international levels. If you found this video interesting, please like and share with your family and friends. And do leave us a comment with your feedback. Thank you for watching.